Alright, this video is for the 12th graders for government class. This is the highlights for Tuesday, March 31st from pages 141 to 147, just the important things to know. So jumping right into it, on page 141, highlight the Judiciary Act of 1789. Know that this was the first bill ever introduced into the Senate. On page 142, highlight the constitutional courts. Know that these are those courts which Congress has created by its authority under Article 3. On that same page, highlight jurisdiction, and that this is the right of a court to hear and decide a case. On page 143, highlight legislative court. For this, know that these have no jurisdiction under Article 3. Instead, they have been created by Congress to try or to handle appeals from specific cases. Also on page 143, highlight the term judges, and that these are the chief decision makers of the federal judiciary. On that same page, highlight the American Bar Association and the definition for this. This is a professional interest group that has the most influence on the president and his choice of a federal judge. Turning to page 144, the only thing you're highlighting here is on the second column. Highlight the term trial, and that this is an official examination of available evidence in a court of law. On page 145, highlight the United States District Courts and know that these are the most active of the federal judiciary courts. On that same page, highlight grand jury and highlight that this is assembled to examine the evidence presented by the prosecutor to determine whether there is sufficient evidence against the accused to try a case. So this is kind of like the trial before the trial. They decide if it's going to go to court. If they believe that there's sufficient evidence for a trial, there'll be an indictment or formal accusation against the individual. If they find that the evidence is insufficient, on the other hand, it'll probably hand down an acquittal. So that means the case is not going to go to trial and the accused is set free immediately. Turning to page 146, highlight trial and jury. Now this is when the case goes to trial. It's 6 to 12 jurors. Highlight that the trial jury actually hears the case in court, and that the trial jury will issue a verdict of guilty or not guilty. On the same page, highlight that evidence is material presented as proof at a trial. Further down that column, highlight the exclusionary rule, and know that this states that evidence obtained illegally is not admissible in a court of law. We'll talk about this a little bit further down the road when we talk about the Fourth Amendment, and this guarantees search warrants, so there can be no illegal searches. On the same page, highlight appeal. Know that this is a request that a higher court review the case records and verdict of the lower court. On the next column, highlight appellate jurisdiction. This is the right of a court to review the rulings of a lower court. On pages 146 on to page 147, highlight briefs. This is the lawyer's written argument. Highlight also precedents. These are past decisions involving similar cases. We'll talk about a few precedent cases, especially in the Supreme Court, that have a huge bearing on decisions that are made today. So that is our last page for today. If you have any questions over what we've covered or any questions over the highlights, make sure that you contact me directly. Have a great day.